Hi, everybody. My name is Liz Abdenor, and as you probably know, your instructor, Desi Clark, asked me to talk with you a little bit about Title IX and the history of it, recent developments, and sort of how Title IX is impacting things at MSU right now. So in your readings, I gave a few different articles that had come out recently about some Title IX developments, and then also a recent Q&A on campus sexual misconduct that was issued by the Department of Education's Office for Civil Rights. So Title IX was initially enacted in, I want to say 1972, but it might be 1973. And basically, it was kind of a response to Title VI of the Civil Rights Act, which had been enacted in 1964, which provided that people would not be discriminated against on the basis of race, color, religion, in not only educational institutions, but also housing, public accommodations, that kind of thing. But Title VI did not protect anyone from discrimination on the basis of sex or gender. So Title IX was enacted specifically to address that. And Title IX initially, as probably a lot of people know, was used to increase equity in athletics. So initially, people sort of thought of it as a way to create women's athletic teams where there had not been women's athletic teams, or create more parity in terms of different sports that were available to women, or numbers of athletes and things like that. And then in the 1980s, people started using Title IX as a mechanism to address sexual harassment and sex discrimination. So there were several court cases that sort of developed that law in the 1980s and 1990s. Essentially, what lawyers were arguing at that time was that when someone is either harassed, discriminated against, or assaulted because of their sex, then that is creating an environment where they're not getting equal access to their education. And so that sort of led to where we are today. And during the Obama administration, there were some developments to Title IX through the Department of Education, which put out some rules and regulations about how institutions were supposed to handle and address Title IX reports that came their way. A lot of that guidance was with respect to sexual assault. But in 2017, in the fall, the Trump administration rescinded two pieces of guidance that the Obama administration had issued, which essentially, didn't completely erode Title IX or anything like that, but took away some requirements. Like previously, there had been a requirement that investigations on campuses be completed within 60 days. There were some requirements about providing accommodations, or what are called interim measures, to people who are going through the process, and a few other things like that. So the 2017 guidance, basically there was a lot of pressure on the Trump administration from respondents and respondents' rights lawyers to say that, they felt that claimants or people who were experiencing sexual discrimination or sexual harassment were getting sort of preferential treatment in the process. So the 2017 guidance was kind of a response to that. And I'm not going to go into all the details of all that because we don't have a lot of time right now. But you can certainly read through the 2017 guidance and then the 2011 and 2014 guidance, and that can kind of give you an idea of what changed. Right now, it's just still guidance. And so a lot of what colleges, universities, and then K-12 institutions do with respect to Title IX is not anything that's encoded in any law. So Title IX is very brief. It just says that any educational institution that's receiving any sort of public funding will ensure that their campus is free from discrimination based on sex. And it goes into a little more detail than that, but that's essentially what it says. So there's no specifics in the law about how that kind of works, basically. So the guidance that's come through has been through the Department of Education, but essentially what that means is that if someone is trying to file a lawsuit, that guidance is not applicable to the lawsuit. So courts can only address something that is a state or federal statute or law, or something that's been developed through case law. So if someone has a complaint about how something is being handled with respect to the guidance that's come from the Department of Education, then that complaint has to be filed with the Department of Education's Office for Civil Rights. And there's also some additional guidance about investigations that's come through the Clery Act, which some of you might have heard about. Essentially, that was a federal statute that was enacted because there was a woman who, I believe it was in the 80s, but I might be getting the date wrong, who had been killed on campus, and her parents were upset about it because the campus that she was killed on apparently had a lot of crime, and there were no crime statistics being published. So there was no way for her family to know that this was a dangerous place for her to be attending school. So the Clery Act initially was implemented to require institutions, higher ed institutions only, so not K-12, to publish certain crime statistics of serious crimes like homicide, any attempted homicide, stalking, sexual assault, any sort of those sort of crimes. And then there was some changes that were made to the Clery Act in, I think, 2016 and 2017. And essentially one of those changes was to add some basic requirements about campus sexual misconduct investigations. So now people can also file complaints under the Clery Act with respect to how sex discrimination related issues are being handled by campuses. But that's sort of the limit unless you want to move forward with a lawsuit, and it's much more difficult to do that because the case law that has developed has essentially created a situation where, in order to be successful with the Title IX lawsuit, an individual has to prove that their institution, first of all, had knowledge, specific and direct knowledge of the sexual assault, that it occurred on some sort of property that they have jurisdiction over. So whether that's on campus or, some off-campus event or something that the university or college would be able to control. But then also that the institution acted with what's called deliberate indifference after they were notified about the assault. And that's a really high burden to prove, because just saying, that the institution maybe didn't do enough, or that they, could have done more, that someone felt unsatisfied by the process, isn't enough to get people past that deliberate indifference barrier. So that's sort of the state of the law right now. And we here in Michigan are in the federal Sixth Circuit. So the Sixth Circuit consists of 4 states: Michigan, Ohio, Kentucky, and Tennessee. And here in the Sixth Circuit, there have been some developments that are different from other circuits in the past few years. So starting in, I want to say it was probably just maybe 2015, but then sort of going through 2018, there have been several cases in Ohio and Michigan, colleges and universities, where respondents have essentially said that they don't feel that the process of the campus investigation is fair to them. And so the way campuses have traditionally handled Title IX investigations is the same way that they handle any other type of discrimination or harassment complaint. And it's essentially what's called a civil rights investigation process. It's a civil rights model that's used in, like, for example, by the EEOC, the Equal Employment Opportunity Commission, when they are reviewing concerns of discrimination or harassment in the workplace, used by the Office for Civil Rights when they're investigating concerns, things like that. And so basically the civil rights model is either an individual investigator or a pair or group of investigators who take an initial complaint from someone and then interview everyone individually. So the person filing the complaint, the person the complaint is filed about, any witnesses, they gather any evidence that's relevant, and then they prepare a written report. And so some schools have then had the investigators also do an analysis and finding based on that report, and determine whether or not their school's policy is violated. Other schools have then taken that report to a hearing. And then there are also some schools that have just done a hearing from start to finish for those situations. And so there's pros and cons to, the investigation versus hearing process. The main pro to the investigation process is that individuals don't have to confront each other face to face, and that people don't have to sit in a room and try to fight out these things that can be extremely stressful and difficult for them. The main con, from a lot of people's perspective, is that exact same thing, that there's no way for someone to directly cross-examine the other person. And so in the student conduct process, a lot of schools do use hearings for things that are not discrimination or harassment related matters. And so there was a student that filed a lawsuit. I think the first one was at Miami University in Ohio, and then there was one very soon after that at the University of Cincinnati, where respondents were saying, hey, this isn't really fair. If I were being proposed for expulsion for anything else at my school, then I would have the opportunity to go to a hearing and, directly cross-examine the other person. And so there was some initial case law in the 2015 to 2017, 2018 time that basically said that, yes, essentially the way that an institution is handling college disciplinary matters needs to be the same, regardless of what the particular allegation is. So then in 2018, there was a case filed against the University of Michigan, and it was a Title IX case filed by a respondent, and essentially the respondent was saying, hey, remember those other cases, Sixth Circuit, where you decided that the student conduct process needs to be the same regardless of what someone is accused of. Well, I'm accused of sexual assault and I didn't get the opportunity to cross-examine my accuser, and I want that opportunity. And so the court held that that is an opportunity that individuals should have if credibility is in question. And so that's really kind of undefined in the case what that means, but my interpretation of what that means is essentially if there are not sufficient facts or evidence to allow someone to draw a conclusion aside from individual's testimony. So, if there were a video recording of a sexual assault, then there wouldn't be any credibility question because you could just watch the video to determine what happened, presumably. Or if somebody went through a criminal trial and pled guilty and said, yes, I did this, okay, then that person admitted it. There's not a question of credibility. But when you have two people or multiple people saying, well, this is what I remember happened and this is what I remember happened, and those things are different, I think that's what the court was getting at in terms of credibility. So not necessarily meaning that one person is more reliable than the other, but just if a fact finder is trying to determine whose story is more reliable, then that's a situation where there needs to be this opportunity for cross-examination. So schools have started to implement hearings here in the Sixth Circuit, those that did not already have a hearing process. And it is going very interestingly, I guess is a good way to put it. So I've worked at, I've had hearings at 3 or 4 different institutions now, and they've all been really different. And basically, so to kind of circle back to MSU right now is in the process of starting their very first hearings. Even though this decision came out in the fall, it's taken them some time to get in order how they want to do this. They had gone through several different options for hearing officers, and the first one didn't work out, and then I think the second set didn't work out, so now they're using an internal person in student conduct, to hear these hearings. So what's happening now is that here at MSU, they're still doing investigations. So they still have this investigator who's gathering information from the parties and witnesses, gathering evidence, writing this report that has a very detailed summary of all the information and evidence that's collected. And then the Office of Institutional Equity is making a determination about whether or not they think this is a question of credibility. And if they determine that it is, then the parties have the option to request a hearing. So at that point, if either party requests a hearing, then it's going to go to a hearing. If neither party requests a hearing, then it goes back to OIE, and they will write up a written report with the findings and an analysis and determination on the case. Now, if the case goes to a hearing, and I'm still trying to figure out exactly how this is working at MSU, if it does go to a hearing, it's not a full hearing on all the facts. Essentially, they're only allowing parties to cross-examine each other on limited topics that you have to get pre-approved by this hearing officer. And I have not done one of these yet in this manner, and I'm very interested to see how it's going to work, because my main concern with this type of hearing is that if the job of the hearing officer is really to assess credibility, I don't know how you can do that if you're just having somebody answer a very limited set of questions that are pre-approved. There's a lot of concerns from my perspective about trying to assess credibility based on the way someone presents to start with. Because, for example, if I say, well, that person is blinking a lot, I think they're lying, or they're putting their head down, or they're not making eye contact. If I don't know that person, I don't know what their baseline normal is. So they might just be behaving the way they always behave. That might not mean anything. The person might have a disability or some type of impairment, or just have, a facial tic or something like that. The person might be tired or stressed or impacted by something else. So from my perspective, I think it's really difficult to think that someone just observing someone else is going to be able to tell whether they're lying or not. And I think if you look at the research on even polygraph tests and things like that, those are not reliable. They're not admissible in court. And I think trying to think that some, student conduct administrator with probably no psychology or psychiatry or medical background is going to be able to determine based on a few handpicked questions whether somebody's lying or not seems pretty ridiculous to me. I don't think it's really what it doesn't make sense to me, and I don't think it's what the court intended either. So I think there's more to come on these cases. I think there's going to be more lawsuits and more, court decisions before we land wherever we're going to land on this issue. But I want to get to your questions now, because you all had some really fantastic questions and more than I'm going to be able to answer. But I want to try to get to what I can. So the first question is, have the changes to Title IX in the last few years impacted the work you do? If so, how? Yes, definitely. And I think one of the main changes has been this hearing process. So here, at least in Michigan and other states in the Sixth Circuit, moving to this process where hearings are happening is a huge change with respect to Title IX cases. And it's making the cases take a lot longer, and it's making the process more stressful, I think, for all the parties. And many more parties are choosing to get attorneys to represent them in this process than did before. It was pretty rare before, especially for people who were the claimants in the process, so the people who were filing the complaints. They didn't normally get attorneys because they just kind of would go through the process. But now, at MSU, if they're having a hearing, MSU is giving people the opportunity of being assigned an attorney who is being paid by the university. But I am representing a number of people who don't want to go that route because, for a variety of reasons, they don't feel comfortable working with somebody who's being paid by the institution, or, whatever the case may be. So that's an additional stressor and an additional expense for people. I think those are really the main impacts that I can think of right now. How can we improve the language in Title IX while being general enough to apply to everyone? So I like this question, but what I think is really interesting is that I actually think the language in Title IX is general enough to apply to everyone. Basically, all Title IX says is that if an institution receives, an educational institution receives federal funding, then they will not discriminate on the basis of sex. That's all it says, which I think that applies to everybody. I think it would probably be helpful if we added in a distinction in the law that this means gender identity, gender expression, sexual orientation, those things as well, because there's debate between different individuals as to whether those things constitute sex or not. I think it's pretty clear that they do, because I don't know what other category those would fall under. But other than that, Title IX itself, I don't think needs a lot of improvement. One thing, though, that I do think is important for us to consider is the fact that, Title IX is meant to create equality or at least equity when we're talking about gender. But, all the rules and regulations that are coming about in terms of how we handle Title IX cases we don't have those same rules and regulations about how we handle any other type of discrimination or harassment case. So, for example, at Michigan State right now, if you file a complaint of race discrimination, of religious discrimination, of discrimination based on veteran status, political orientation, any other protected category, you will not be going through this hearing process. And so I think one thing that's interesting is that we don't actually have an equal system when we're talking about complaints related to sex. People are going through a different process. And so I think one really interesting question here is it fair for us to treat different types of civil rights investigations and processes differently? I don't think that's a good thing, but I don't know what the future holds for that. In one of the articles that I had you read, or it might have been the complaint that I gave you all if you happen to read it, it's a complaint that was filed by an attorney in Massachusetts, and basically she's arguing that that Title IX and the regulations that have come about actually constitute gender-based discrimination because we are creating this sort of different set of rules and regulations for people based on sex. And that attorney is actually a really strong advocate for the passing of the Equal Rights Amendment. And so if you're not aware, excuse me, gender and sex is actually not protected under the Constitution. The Equal Rights Amendment has been ratified by, I want to say 37 states right now. And if we get one more, then there will be an amendment to the Constitution stating specifically that people are equal on the basis of sex or gender. But we don't have that right now. And so that creates some interesting questions for people about whether we need to have a constitutional amendment or not. I personally am definitely in favor of that. But it's something that, in the past has created a lot of distress for people because there are certain situations where people think about being treated the same on the basis of sex that have made people uncomfortable. And so, one really important example, I think, is with respect to the draft. So people were uncomfortable at the time in the 70s when the Equal Rights Amendment was initially being proposed with the idea of women being equally exposed to a potential military draft as men. I think, probably now people would have some different opinions, or at least some people would, but that was a barrier at the time. Let me see. Some of these questions are kind of repeating each other. How do you working with OIE restrict one's ability to bring justice to survivors? And beyond that experience, how does working within the legal framework of sexual violence impact your personal well-being, and how do you cope with it? So it's two different questions, but I can certainly answer both of them. So when I was working in OIE, definitely my job was not to be an advocate. So I don't work at OIE anymore. I have my own law firm and I represent individuals going through OIE processes, either at MSU or similar processes at other schools. And then I also do special education work in the K-12 context, so that's separate. But, in OIE, I saw my role, your job is to be a neutral, unbiased investigator. And I thought, from my perspective, I'd worked as an attorney for a while before that as well, it's very important to have a system that works properly in order to have a just system and to bring justice. And so while my job was not to advocate for anybody in OIE, and I tried to do my best, if I felt that for whatever reason I might be impacted, that I would flag that and say, hey, for whatever reason, I don't think I should be handling this case. Can it go to somebody else? I also it was really important to me that we have a fair system, because the system doesn't help anyone if we have an unfair system, because what will happen then is, let's say I'm doing an investigation and there isn't really sufficient evidence for me to make a finding, but if I feel sorry for the person and I make a finding, what's going to happen is then the person that the finding was made against will have a really legitimate and reasonable opportunity to appeal. And so what that will do is just drag the process out longer for the individual who filed the complaint. They will think that they, quote unquote, won and that they can move forward, and then they'll find out there's an appeal. And if I was not unbiased in my investigation process, they're going to win that appeal. And that's just going to create a lot more stress and drama for everybody. So for me, when I worked in OIE, it was about creating as fair of a process as I thought I could. The process is still problematic because I think now that I work outside of OIE, I realize how completely convoluted it is and how nobody like understands what the heck is going on in there. And it seems like this black box that stuff just kind of goes into and nothing comes out of. I did not really realize how bad that was when I worked there, but I think having a process that is equal and fair is really important, because even if people don't have the outcomes they want, um, knowing the sooner you know that you don't have the outcome you want, then the sooner you can move on and heal from that experience. And so dragging that out through a bad process is just not fair or helpful. So that was what I thought I was doing in terms of justice when I was in OIE. Working on sexual violence, absolutely. So, that is something that certainly can impact your well-being and your stress levels and things like that. It's really intense. You're dealing with people who have gone through serious trauma. A lot of times people want more from you than what you can give them, understandably so. And so I sort of learned how to deal with that really when I was in law school. At that time, even then, I was working with a lot of survivors of domestic violence in particular, and immigrants who had been through some really traumatic experiences. And at first I found it really overwhelming. I was, going home and crying and feeling stressed and thinking to myself, this person, like, their life is just such a mess. I don't know how it's ever going to get untangled. But what happened is that for me, the way I deal with it, and this has been super effective for me, and different people are different. But when I started representing people as an attorney, and I had my first few cases where I saw the case go all the way through, and then the person moved on, and then they moved on with their life, that was sort of a real, a click of a moment for me, because basically I saw people going through the absolute worst situations, people who had repeatedly experienced trauma and who on top of that were losing their homes, potentially losing their children, losing their marriage or their partnership, struggling financially, you name it, and these people were dealing with it. Sometimes disabilities, sometimes mental health issues, sometimes substance abuse issues, like tons of stuff. And then, so I would see them at these horrible points where I was like, how do you ever get out of this? And then they did, though. We got through it, they got out of it. And then some of them, they would come and reach out a few years later, and, they were doing well and things like that. And so for me, I just always remember, like, it's just something I know, like, no matter who I'm dealing with and no matter how bad it is, I know that person will make it to the other side. My job is just to sort of walk with them through this bad time, but I know that they can make it to the other side and that they will have a great life in the future, because I've seen so many people do that. And so that moment when I realized that, and it wasn't like it was a specific moment, but just sort of that education process of becoming a new attorney and going through that with my clients, that has kept me that has given me so much peace of mind. And so, I can deal with the stress and the trauma that my clients are experiencing. And I have colleagues that I debrief with. So that's really important, having people to talk to about, what you're going through and what your clients are going through and your stresses about it, and people who understand what that's going through. But I just always have in my mind that I know that these people are going to be okay, no matter how bad it is, whatever they're going through, I know they're going to be okay, because I have had so many other people be okay going through really bad things. So, that's sort of how I personally focus on that. And then, having balance, I try to, I've been trying really hard lately to not check my email past a certain time on evenings and weekends, and get outside and play with my dog and all that kind of stuff. But the number one thing for me is just keeping in mind, at the top of my mind, how resilient human beings are. And that is my number one coping strategy. How do you feel about mandatory reporting or compelled disclosure? I have mixed feelings on this. I do not have a set opinion one way or the other on that. The pros of mandatory reporting are that potentially more people are held accountable, which I think is important, because when you look at a situation, the best example is the Larry Nassar situation, where people were trying to report Larry, and they were talking to coaches and strength and conditioning staff and colleagues and professors and, all these different people, and nobody was doing anything. And this allowed this horrible perpetrator to continue for many years. So from that perspective, I think it's really important. But on the other side, I think it also, removes agency, obviously. So if somebody is talking to someone, they think in a one-on-one way and just trying to get advice, and then they learn that person is going to have to report what they told them, that will put their life, totally upside down, and not necessarily for the better, because that process may not be worthwhile in the end to them, depending on what the outcome is. So I'm mixed. I don't know what the solution is on that one. How do you think reporting systems can be improved? So, one, I think if you are a mandatory reporter, starting every relationship with that information is extremely important. And I think still at many institutions, people are not doing that. So just if somebody knows at the outset of their relationship with someone else that that person's a mandatory reporter, then they can determine how they interact with that person before they get to the point where they're close enough that they want to share things, and that may not be safe or comfortable for them to do that. Also, I think if there are places for people to go where people are not mandatory reporters, I think that's really important. And so I know at MSU, the sexual assault program and MSU Safe Place are places that those individuals are not mandatory reporters. So if students have questions or concerns, they can go there, talk, and be able to talk to somebody and not have it reported. So I think that's really, really important too. Trying to think, I'm sure there are other ways to improve it, but that's all that's on the top of my head right now. Do you believe universities fail to acknowledge their shortcomings in the reporting systems they have in place? Yes. Do I think any institution or bureaucracy fails to acknowledge their shortcomings in every arena? Yes. So that's a pretty easy one for me. There's a lot of concern about limiting or minimizing liability that I think sort of overcomes kind of the human side of this, which I think it is what it is. It's problematic, but I don't think it's going to change anytime soon. Let's see. Being that you work so closely to MSU, what do you see is the main issue that MSU has when dealing with discrimination and sexual assault? Quite frankly, I think their main issue right now is the fact that no one trusts their Office of Institutional Equity to handle things properly, and the sort of subset of issues under that. So the amount of time investigations are taking, the wide variety of different information that people get depending on who they talk to in the office, these investigators that they have who seem to not even have any basic training in things like civil rights or trauma-informed interviewing or things like that. I think that's a major issue that they need to resolve before they're going to get to a good place. Because if they don't have a place where people can go that they trust to report this stuff, then it's just going to keep happening, and it's going to get worse and worse. Do you believe MSU's Nassar case helped improve the school's response and prevention of sexual assault, or further re-victimize survivors on campus due to the crackdown on mandatory reporters? I think both. I think both of those things happened. I think the school, I don't even know that they fully realize the problem that they still kind of have, but they definitely realize they have a problem. But yes, the mandatory reporter thing was really difficult for a lot of people. So I think it goes both ways. Do you agree with the way MSU handles sexual assault cases? So I like this question because I have no idea how to answer it. I really think when I think about this stuff, the way my mind keeps going back to is, a civil rights framework needs to work the same for every type of discrimination and harassment. So you don't have an equitable system if it's not equitable in terms of how it's handled. And right now, MSU is handling reports of, race, national origin, religion, those kind of discrimination and harassment cases differently than they're handling sexual assault, sexual harassment, stalking, relationship violence. And I don't think that is fair or equitable or just. I think and I don't know what the solution is and which way is the right way to go, but I think handling sexual assault cases differently than other types of discrimination and harassment is problematic, and MSU is doing that. So I have a lot of concerns about that. I don't know that anybody's having that conversation at MSU. And I think it's going to lead to a really problematic situation. What should a student do if they feel that an institution has not done all they could do after reporting an incident? So you have some opportunities and some options, which is great. I will tell you I'm no Betsy DeVos fan, but the Department of Education has a lot of good people working there in their regional offices. Those are career, lifelong civil rights attorneys, investigators who work on the cases where complaints are filed. So I think filing a complaint with the Office for Civil Rights in the Department of Education, or the Clery office, which is another option. I think those are some realistic options. Now, those investigations take a long time, but I do think that, especially at MSU, those offices are paying attention. And I think that's a really good way to go if you have concerns about how your school handled a report. I think talking and being public, students do not realize this. I can tell you as a former university administrator, they are terrified of you. They do not want you to march. They do not want you to, have any sort of public demonstrations. They do not want you to write articles. They do not want you to speak out in the paper. It freaks them out. They hate it. So do that, because that gets their attention, whether you realize it or not. They are absolutely, like, it's all they can talk about when it happens. So, public demonstrations, talking to the media, those kind of things. I think those are really powerful things. You all have lots of power, and I think lots of students don't know it. I know I didn't know that at all when I had a student. Use your voices. They are scary to administrators. I think I'm coming up on my time, so I'll just see if there's anything quick. Let's see. There's a couple personal questions here I think I can answer real quick. So what made you want to open your own law firm for Title IX? Because I am literally, as far as I know, the only attorney in the country who is representing people in Title IX cases who also worked as an investigator in an institution. I mean, of all institutions, MSU during Larry Nassar. I think I have knowledge and experience that is super valuable to people going through the process that nobody else has. And I love advocating for people. I'm also, like I said, doing special education work, so representing K-12 students with disabilities and getting the services they need. I just love helping people where systems are kind of against them, and I feel like my skill set, because of my experience working at MSU and then my prior experience representing survivors, it's something that I don't think anybody else really has, even nationally, that I know of. And so I was like, I gotta do this. So that was kind of it. I got involved in working with Title IX because back in 2014, I was working at a nonprofit, mainly doing family law work for survivors. And I was reading in the news about, at the time, 2014, MSU was doing a terrible job of investigating sexual assaults in Title IX cases. The cases were taking 200 or 300 days to investigate. And I was like, what the heck is this? What is going on at my alma mater? Because I'm an MSU alum, and I need to go work there and fix it. And that was what I thought. And so that's what started me working in Title IX. I had no experience in higher ed before that, but I did have experience, obviously, with violence, sexual assault, relationship violence, that kind of stuff. So that was what I was just like, what is going on here? And I need to fix it. And so that's what started me down that path. Let's see. Oh, I like this one. As a woman, do you think that people in the field inflict stereotypes upon you while working on such cases? Women are often viewed as too emotional, blamed for their experience, or teaming up with men combating sexual violence. Do you think that you have to fight these stereotypes while you fight for women's rights? Yes. I mean, you have to fight, as a woman, you have to fight stereotypes all the time, but as all, men have to fight stereotypes too. People of color have to fight stereotypes, people with disabilities, everybody. So yes, I definitely think that, people think that, I'm doing this for personal or emotional reasons rather than, a desire for justice. But I think those things are kind of tied together. So I don't really, that doesn't really bother me too much, because the way I view that kind of stuff is, if you're gonna underestimate me, then that's actually great, because then I'm gonna just run all over you. You know what I mean? So it's like, if you think I'm just emotional and not, super knowledgeable, and you think that, what I'm doing in my work is, just about my own personal stuff, then you are going to seriously underestimate me, and I will be able to succeed with great vigor or whatever, when we get to court or whatever, at whatever point we get to. So I don't really let that stuff bother me too much, because it definitely happens, like, a lot. But I'm just like, I'm probably smarter than you, and now you think I'm dumb, so I'll just take that. So that's my own personal thing. Um, I think that is all. But I do want to let y'all know that you are welcome to reach out to me if you want to, if you want to talk about, if you're interested in getting into this work, or if you have any other questions about, you know, my work, or anything going on at MSU. I am not a mandatory reporter, and I know the MSU system well, so you can definitely reach out to me if you have any questions about anything that you're going through, or a friend, or anything like that. So yeah, it's been really great talking to you all, and thanks again to your instructor, Desi Clark, for asking me to talk to you all, and she can get you my contact information if you want to reach out afterwards. All right, have a good day. Thanks.